Thank you everyone and welcome back to Kata-Kata Kita. My name is Adib Kosnan.
I am Molly Mota.
And that is Kok Heng Luan, who is counting the audience whether they are back or not.
I'm sorry.
Daydreaming.
No,
Yeah.
thinking about just now the play lah.
Yeah, and I think it's very thought-provoking. And today, our guest, who is generously donated his time here today, will be helping us to talk through some of the issues that we just watched. I'd like to welcome Mr. Mohammad Rizuan bin Mohammad Yasin. Can you give him a round of applause, please? Rizuan, please take a seat. So, Mr. Rizuan is a lawyer who frequently deals with issues such as the one that the family has seen, right? So, Rizuan, just wanted to start off by asking, so, looking at what the family went through, right, are these very typical issues that a Muslim family contends with when it comes to estate planning and legacy?
Okay, first of all, thanks for having me here. The video was a very interesting video, and it's quite common that people have this kind of misconceptions when it comes to estate-related matters, whether it's the house or their share. This is an issue here.
So, what are some of the common, like, maybe issues that practical issues about legacy planning that occurs immediately after someone passes?
Okay, generally, I don't think people do it immediately. Most people take some time to grieve and all that, unless, like in the video, someone is really rushing because they need the money. Maybe, I don't know, that's what I assumed. Normally, people will take some time, then they will try to do it themselves. When they face obstacles, or the bank tells them that you need an administrator, then they come to the lawyer and do a grant of letter of administration. If there is no will, if there's a will, then it's a grant of probate. So generally, that is the situation.
So typically, actually, it's up to the family to basically deal with the shares on their own.
So they will try, but obviously they will face obstacles. Then they will have to come to the lawyer and try to settle the matter. So okay, there is a few things. For example, for example, assets are not just cash, right? You also have CPF, you have insurance, you have car, you have the house. So it really depends. House also you have difference between if it's a private house or HDB. There are certain, HDB you have to follow the act and all that. So, for example, if the CPF has been nominated to one particular person, then that's it. There's no need to worry more about it. But if it has not been nominated, then you have to go and either get the lawyer, get the forms and all that and deal with it. Yeah.
So, in terms of the nomination, you mentioned that if it's CPF, if it's nominated, then that doesn't have to be dealt with because the nominee will receive it, right? So, how then does it work when somebody has a will, like in the case of their father here?
Okay, first and foremost, for Muslim will, right, there are certain limitations. You can't just will away anything. You have to basically, there is the faraid component. You have leeway, I would say, to deal with 1/3 of your assets upon your passing. When we say your estate, right, it's what's left behind, things which are in your sole name. So for example, like in the video, the house, the HDB house would no longer form as the person's estate because in joint tenancy, the youngest son now is the owner. So that house is no longer part of the estate. There's no need to have a discussion about it. Yeah, so what is left behind, that's what's in your estate. And then when you, what was the question again? Sorry.
So once the will has been dealt with, right? So what happens then? Like they were asking about just now the question that
on the Muslim will. Sorry, I lost my chain of thought. A bit too 9+. I didn't have my tea. I lost my chain of thought. Okay, so in a Muslim will, you can deal with your estate however you want with 1/3 of it. So if 1/3 you want to give it, let's say to an organization, a charity, whatsoever, do it. You want to give it to an adopted son, someone who is a non-beneficiary. How do you know who is your beneficiary? If it's a Muslim estate, you go and look at the Sijil Warisan or the inheritance certificate, which you can extract at the Sharia court, if you want, you can actually on your phones and go to the Sharia court page and use the online inheritance calculator to give yourself an idea. If it's for non-Muslims, then either the will or the intestacy act, right? So that's pretty much the situation. So a lot of people say, I want to will my house away to one child, the child who took care of me. Obviously, then, unless the other children agree, the will cannot be operated. It's not operable anymore. Yeah, it's void.
So that means the beneficiary under the faraid kind of arrangement means that those beneficiary can contest that will decision.
Of course.
Okay.
So in the case of, let's say we bring it back to the family, right?
Yeah.
Let's say the father, in his will, hypothetically said, I want to give 1/3 of my wealth to the sister because the sister took care of me, right? That will only go through if the other beneficiaries do not contest.
Okay, then I have a question then. Okay, usually for Fara'i, right, the man usually will get more than the woman. And then, but usually the caretaker are usually women, like the story here. So my question is that, okay, not why, but you know, what I understand is that why men are supposed to get more because they're supposed to be looking after the women, right? So I'm so scared to ask this question somehow. Okay, but my question is, can the women, like sister Azura here, can she actually contest if Azhar or Ashraf did not take care of her in the end? Where can she go? Or can she, you know?
I didn't expect the question, but
thank you.
obviously I have the answer. So because people have asked me these questions many times when they come and see us. This topic of estate planning is a very popular one. So everybody likes to talk about it. Whether you have money or no money doesn't matter. You want to talk about it. So and actually, to be honest, most people nowadays I'm very afraid to use this kind of generalized statements. You see, like most people, but based anecdotally at least, people have a few $100,000 when they're going to pass on, at least even a 2-room flat, 3-room flat, 4-room flat, some bank savings, some CPF. You know, they have at least 6 digits. Not all, but at least those I've seen. You know, so back to your question. In Islamic law, yes, the brother or the male gets more than the female. Obviously, the responsibility is to look after everyone, including the females, right? And himself, of course, with the money. But if it doesn't happen, under Singapore law at least, I don't think there is any remedy that the female can actually, she can they can look after her complaints in the matter. But in a Islamic country, it also depends what kind of Islamic country. So then you would have to probably make a complaint. I asked this question many years back to a religious teacher of mine. A lot of complaints, right? People say, I am the one who took care, but they get 2 shares. So I was told by a religious scholar that in a scenario where the state is, for example, like Sharia is the law of the land, then the mufti can make certain decisions in order to assist the female family members if the brother is not responsible towards them. Like, for example, in Singapore, you have the maintenance of tribunal for maintenance of parents, right? So something like that, the like thereof, they may have over there. But under Singapore law, no. Now, there's obviously debate going on. It's been going on even before I became a lawyer. I might have a bit of a longer beard, but I'm not old. I'm only in my early 30s. So don't think that I'm in my 40s or whatsoever. I am not. Okay, so people have been saying Muslims should be given the right to give their assets, let's say following the Intestacy Act or whatsoever. Some say no, we have AMLA, Administration of Muslim Law Act, let's just follow that. So it really Depends which school you're from. If you look at Facebook, you will see that there are many schools, but I don't know in reality what schools are there. So far, you have to follow Islamic inheritance law if you are a Muslim and you're Singaporean or you have been domiciled in Singapore. Now, the domicile part, if you are a foreigner and living here, a bit of complications. I don't want to go into that part a bit. Let's just talk about Singaporeans for now.
Sorry, we just need you to speak closer to the mic. Yeah. Yeah, you have a question?
I have a question. So if you in the play, what happened was that the father had some kind of foresight, right? So because he learned from his mistake, and then he brought his son to go to the to meet lawyers like you, in order to understand how it's being distributed, so that he could make the will. And is that common? If that is not common, say somehow the family used the calculator and they may not have done it properly, and then they distributed it, but there was no immediate contestation because no one knows. But somehow, someone then realized that, hey, I don't think this has been distributed correctly. Can they seek a recourse?
So there are steps to go and seek a recourse. That one, there is legal procedure with that. If I explain to you all, it might take quite some time. So I think suffice for now that there is such a procedure where if the estate has been distributed in an erroneous fashion, you can then go back and seek redress at the courts. Yeah, but in relation to your first question, you asked something first.
Is it common that people will go and look for a surround?
People do come, whether Muslims, non-Muslims, they do come down. And last part in the story is something that I would say is not so uncommon. The fact that one child is actually a joint tenant. So, and I do not know why these type of things happen. Based on my own experience, it happened, say, 10 years, 15 years ago, or maybe 20 years ago, where it was easier for HDB flat context. It was easier to go and put your name as a joint owner. Then, that's what I understand. If I'm wrong, you can correct me. It was easier then. As far as I understand now, it's not as simple or as straightforward as it was then. So in the past, and I also don't know what is the motivations to do it, perhaps something to do with maybe compassion for a child, youngest child, or the child who is probably most vulnerable, no financial support, or maybe just to lend a name for refinancing or whatsoever, whatever the reason may be, right? So they put themselves as a joint tenant. And then there are other siblings, and the other siblings know that this sibling who is now a joint tenant actually did not put a single cent in the house. That this is actually my father's flat, right? I mean, I always be assuming that the father dies first. I don't know why, but this is my father's flat. Then my mom survives. Then she took one of the siblings and put the sibling's name in the house as a joint tenant. The house was perhaps fully paid, right? And the mother did not know that by putting as a joint tenant, my children don't earn the rest of my children don't get a share from the flat. So they don't know. And until the fatwa on joint tenancy came about, there was a lot of confusion on this in the Muslim community. A lot of confusion. Must I now sell away the flat? So for example, if there is there's a wife and there is perhaps she has no kids, or perhaps let's say she is national of another country, she doesn't know much about the law, then the siblings come and pressure, you better sell the flat now, give us our share, and so on and so forth. Yeah, so we must just bear that in mind.
There was actually something one of our callers yesterday went through with her mom, her late mom, and when her late dad passed on. So yeah, I think it is something that still occurs in our community today.
Yeah. Sorry, maybe I missed out on it. But just now, because Ashraf is the joint tenancy, right? So Azhar actually can still contest. Is that what you said just now, or did I misunderstand that? Cannot.
No, right.
It's taken totally out of
But
the...
if Ashraf sell the house, the money is all Ashraf's, right?
Of course.
Oh.
Because he's the owner now. when he sells the house, he does not need to give the money to anyone. Because a joint tenancy situation are very simple. The right of survivorship applies. What's the right of survivorship? So A and B own the house. A passes away. B owns the house fully. A's rights extinguishes upon death. So B will own the house fully. So we must understand that. It doesn't have to, discuss, make any proposal whatsoever. Nobody has any right to tell you what you want to do in your house.
So that's the same case with insurance, if there's nominee, as well as for CPF, am I right? Yeah, okay. I do have another question, which is about executors. So in a way, like, in LPA, right? So someone is being nominated to be the executor of the estate, of the decisions and the wills of the father in this case. And just now in the play, the elder brother exerts his authority actually to make decisions. So in this kind of situation, if let's say the father has already said, okay, Ashraf will be the one executing all my decisions. So how do we resolve this?
I think in the clip, who's the elder brother? What's his name?
Azhar.
So Azhar, I think, is under the misconception that as the eldest son, he has some special duty or responsibility suddenly on his shoulders, but no such thing actually exists. There is some truth to that. He has a thing called, he has higher share, right? So let's say if he was the only brother and the other two are sisters, then if they want to become the administrator, they need his consent because he has higher share. You see, he has a higher proportion of the share of the estate. They need his consent before they become the administrator. But if in the will it is stated that someone is the administrator, then that's it. You don't have to worry about it. So it's always good to write the will. Like what I said before, the will, you can choose what to do with 1/3 of your estate upon your passing. The second thing is to choose an administrator. You can also choose administrator. You can also say probably when you want the certain things to be sold. Maybe you want the person to stay in the house. Now this may have problems, obviously, if there is a minor and you want him to stay in the house for 10 years and it's a HDB flat, life interest and all that, it would be problematic. Private homes may be simpler, But there are a lot of things you can write in the will. Like some people choose to write, they have 4 children. They have no home of their own. They're living with the children. So when they pass on, where would they want their body to come back? Bring back my body to this house, do this, return my money back to certain people, and so on and so forth. So it really depends. A will can be a very simple document. It can also be slightly complex. Yeah, it really depends. You can also have 2 administrators, not necessarily 1. Yeah, so you can choose. Yeah.
So a will does cover the wishes that are not specifically financial also. It can cover duties and things to carry out. And maybe my question to you is, what have been some of the things, like the examples that you give, what have been some of the things that people that have stood out to you about what people want their loved ones to do after they pass?
Well, I've had many scenarios. Sometimes people come to me with their auntie, and the auntie says, I don't trust my son. I want him to be the administrator. So I want to do a will where he becomes the administrator. Then the nephew tells me, but I don't want to get into trouble. I say, look, I cannot be advising the whole family. You all, you just ask your auntie to sit here. You sit outside. Let me speak to her. Let me explain to her the situation. But sometimes people may not understand the consequences of what they do. For example, you're putting someone as an administrator, and then you're expecting that person to go and discipline your adult children who you failed to discipline your entire life. How are you going to, is he going to control them? So there's something, so they want, this person is a respected person in the family. He will decide when to sell the house and so on and so forth. But the administrator has a duty towards the beneficiaries. If now the administrator acts in a manner contrary to that of the beneficiaries, then you can go and apply to remove the administrator, change the administrator at the family court. So we must understand one thing. You get for Muslim estates, you get your sijil warisan or the inheritance certificate from the Sharia court. But any estate matter is litigated or contested in layman's term at the family court and thereafter the high court, not at the Sharia court. Sharia court, they do divorces, talak, cerai. That's what is done at the Sharia court. And then they give you the sijil warisan. That's it. So you must understand that because you have to go to the family court to obtain the grant.
I've learned something new today, definitely. Yeah. As we are processing as well, I mean, if there are any questions that you in the audience have or people online who want to ask Rizuan about it, please, the lines are open.
Any questions from the audience? Or else will we just keep asking questions?
Any question?
Don't be shy. There's no charges.
Yeah.
He will charge to BSN. Yes. So what they are thinking, so I'm going back to just now what you share about, because it will be litigated in the family court, right? So the basis of the family court is based on whatever existing law we have and not based on the Islamic law.
Good question. So family law will adjudicate based on Muslim law. So
Okay,
we must understand that there is a court case to actually say that Muslim law in Singapore is the law of the land. It's not foreign law. Because we must understand all the acts of the past. See, I'm not very good at memorizing all the old acts. You have all the Strait Settlement during the British times and all that. They came up with different acts for different religious groups and all that. So that's why the joint tenancy fatwa came up from the case in 2009 or 2011. There was a case, and the Court of Appeal adjudicated whether this thing exists or not, and so on and so forth. Even Nuzriya, right? I'm sure some of you may have heard of Nuzriya. Nuzriya simply means Nazar is a vow. So Nuzriya is that document where you write your whatever vow you made lah. So there was a case in the High Court in 2004 where even the Mufti's expert opinion was sought, and the High Court said that Nuzriya it's not valid, you see. So that is in the High Court, but Muiz Fatwa still says it's Nuzriya is something that is valid. So that case actually is not so simple for us to distill. There are a lot of observations and so on and so forth in that case. But simply put, it's not as straightforward as you think it is. So it's always better to do things, understand first what are the requirements, and then you also have a choice to handle it howsoever you want. I must tell you, Muslims have that choice. So just that you have to consult your beneficiaries. So when you consult your beneficiaries and everyone has agreed, then what do? You just makan, have teh tarik and go back home? Well, what do you do then? What's the next thing to do? Execute a deed of family arrangement. Sign it. Everybody sign it before the lawyer. Then it's fine. Then the court will be okay to accept it based on the deed. But everybody must again, after the testator has passed on, this is the convention and procedure at the family court, they must all come again and sign. If at that point they refuse, there can also be a problem. Then people must sue on the deed. So these things are very complex later on. Yeah, but many a times, just adding while you all think about your questions, I just add a little bit. Many a times, certain things can be resolved very easily. For example, mother and father, either one passes away, the mother or the father owns a flat entirely. Then the bank accounts, let's say they had it in joint bank accounts, goes to the other party. Then CPF and insurance, let's say prior nominated already, don't have to worry. I also know there are people who just see some jewelry or whatsoever, maybe 10K, 15K worth, they just say, Anna, you keep this, finish. Some people they really respect. If they say, look, I know that dad wanted this, or mom wanted this. Let's just follow. She wanted to give all the jewelry, let's say, to the youngest daughter. Then just give it. So why we say do this deed of family arrangement and all these things? Because it's good to have things in writing. Always good. So you don't forget the original intention, the original purpose. Not to say that man is deceitful. I'm not saying that. Maybe forgetful also. Or maybe a mix of the two. So it really depends how you see it. So the best thing is, I would say always, write things down, helps you out at the end of the day.
So I guess this is my interpretation of that in a sense. If it is about making something that potentially could be contested by the beneficiaries, and you have the deed of family arrangement, it means to have that conversation, right? You have to have that conversation. If not, nobody will know about this, and then people will contest. Which brings us to what we've been talking about these past few nights, right? About talking about this and talking about not just the tangibles, but the intangibles. And in this case, it could be a mix of both, right? What you want to be done after you leave, how you want it to be done. Yeah. So I think that it's interesting that even you don't have to do it, but if you do, it safeguards against it being, like you said, contested, or people forgetting, or people wanting to use it in a manner that does not benefit the beneficiaries, right?
Any question from the audience? There's an audience in front. Yeah. Thank you. Please speak to the mic, and if you can stand up. Yeah. No.
Actually, I don't know how to phrase this question. It just suddenly came to me when you mentioned. So, like, what about a situation where one of the siblings is estranged, like they just isolated from the family, no contact whatsoever? Then, like, how do you go about with that kind of situation? Yes, yeah.
Any other questions, like part 2 or something?
No, because like it just came to my mind, like,
Okay.
like, because what we talked about is more like everyone knows what's going on. But then what about the situation where, like, after the parent passed, and then we don't know what, like, the kids don't know what's going on, like something like the family, except the youngest know what's going on. But what if no one knows what's going on, and then there's someone who's estranged, and then I don't know how to phrase it properly. I hope that makes sense.
Such situations are not entirely uncommon. But most of the time, people have their names and IC, so you can still extract the sijil warisan. Just because you are not in contact with them doesn't mean you can usurp their share, obviously. Just because you're not in contact. But if you don't even know their name, you don't even know the IC number, let's say the person is in some, whichever part of the world he may be in, he or she, then how do you get the details? So you just have to proceed with whatever you have. Later, if there's a challenge, then it's upon the person to go and challenge it. But also, we must also understand what happens if there are children from unregistered marriage overseas. How do you deal with such a situation? Answer is there is no very clear answer. Some have said, based on certain statements by the authorities and all that, or ministers in parliament, that we want to recognize the marriage which is in Singapore. But what happens if there was a marriage overseas, there are children, what are you supposed to do? So people will ask these questions, and they will always ask this question. I must always ask them to clarify. Are you asking me this from an Islamic perspective? Are you asking me this from the Singapore law perspective? So it really makes a lot of difference, that question. Because they ask me from an Islamic perspective what I should do, then I'll say, look, I'm not a religious teacher, I'm a lawyer. Go and approach a religious teacher. Ask the religious teacher what you should do, what is right, what you ought to do, right? But if you're asking me from the Singapore law perspective, then I will tell you, you should do this or you shouldn't do this. Or you must do this or must not do this.
Just taking from there, if let's say you ask this religious teacher and his advisors this, and someone contesting it says, my religious teacher says different, then how do we resolve that?
Okay, this one doesn't always happen, but religious views of religious scholars, as they call themselves in Islam, ulama. So their views are similar to expert opinion tendered in the court. The ultimate authority arbiter is the court. The court will decide based on opinions.
Okay.
So whatever a religious scholar say, that does not mean, it is what it is, right? So as we all understand in Islam, in the Sunni school at least, there are predominantly 4 schools of thought. So the 4 schools of thought, all are respected, and they say all are right in their own ways, because the basis is, at the end of the day, they're interpreting the Quran and the Hadith. Yeah, so that is the school. But within the schools of thought, there are also differences of opinion, and this is in a way actually not something that is perplexing or confusing, but is also Muslims see it as a mercy, because it helps you as when you're in different circumstances, when traveling in the aeroplane, or when going to a country, let's say if I'm not wrong, I watched a documentary in Iceland or what, they have just 1 hour to break their fast, do the Maghrib, Isha, Tarawih and Sahur in 1 hour. I don't even think you have time to go toilet. So it is an issue, you see. So it allows you to apply in different contexts. So even in Singapore, there are cases where parties ask, what is the school of thought of this particular person? Yeah, because if you look at AMLA, they said we apply Muslim law as varied by Malay custom. So there is also Malay custom here. I think I see someone raising.
There's a hand.
Yeah.
Finish your statement first. The lawyer.
It's okay. I think we can go to the question.
Just want to share a bit about the AMLA part. Okay, because I think there was a bit, just to clarify. First thing about the school of thoughts. Okay, what I had done for my own family was we approached the mosque. Okay, the point of contact, because they have a religious officer. Typically, it will be the head of the executive officer. Okay, the imam or his subordinate, who has the right to sign a form to say that these are the faraid apportionments done and all that, and with the MUIS job. So what we did was we shared with all the beneficiaries as a proof that this was done legally, legit, everything. So in my own work, I also always ask my clients to approach the scholars at the mosque itself, because in Singapore, MUIS is the authority for such cases. Especially when you said just now, there was those cases of people who has other marriages outside Singapore. So at least with the authority from MUIS, because these religious officers in the mosque, they are regulated and authorized to give certain statements and certain fatwas and all that. So use that at least to minimize any conflict between the families. Thank you.
Thank you. And I think the idea of resources, right? Sometimes when things happen, the question people ask is, where do we go? And that is one of the places that we can definitely explore and go to at least have a clearer idea of what we can do moving forward, especially in times when you may not have had those conversations before.
Actually, I have one last question. I'm so sorry. Okay, about Faraid again. Because, you just triggered something. So if it's mixed marriages, if the husband pass on and the wife is not a Muslim, but they have kids and the kids are also not Muslim, does the Faraid, do they still fall under the beneficiaries of this Faraid?
Okay, so Faraid simply means Islamic inheritance law, right? So if a Muslim marries a non-Muslim in civil marriage, that marriage is obviously legal according to the law of the land, but in accordance with Islamic law, it is obviously not valid, right? So, But that has nothing to do with his, nothing really to do with his estate, because only a Muslim can inherit from another Muslim. So that is the law. It's very clear. So if he marries a non-Muslim, a controversial question.
Sorry.
Later, but it's okay. I have to answer. I can't run away from this. So I didn't raise the question. So then the non-Muslim spouse unfortunately cannot inherit, but he can obviously make some provision in that 1/3 portion of the will, right? But also, and this was also stated in the Court of Appeal case just about some 10 years back. If the wife is a non-Muslim but a joint tenant to the flat or condo or landed, then does she get it?
Yes, joint tenancy.
Joint tenancy, but she's not a Muslim.
But it's joint tenancy.
But doesn't matter. She's not Muslim. So how does it does it work?
I would think it would work, right?
It actually works.
The land of the law.
Because the law of the land,
Law of the land is
precedence.
yes, takes
That's what the
precedence.
Court of Appeal said also, public
Yeah.
policy wise. You know, the law of the land takes precedence. And you can also, you see, there is no reason to be despondent, if I may say, that the will may give you certain limited options. Obviously, you can do whatever you want when you're alive. Let's say you're alive, you are sane, you have no unfortunate mental illnesses or whatsoever. You can donate everything to SPCA. It's fine. Nobody can stop you. Donate something to a kitten foundation or something to feed strays around the estate or whatsoever. Nobody is stopping you. So you can also do inter vivos gifts. You know, gifts when you are living. Thing called hiba. Huh? You can give it to people. It also applies for the non-Muslim. Hiba just means gift also. So you can do a deed of gift, as they call it. Give over. You have a Rolex, you want to give over. Some very old Rolex watches can really fetch a good value. So you write it properly, give it. But obviously you must understand, when you see the lawyer will give you certain conditions for the gifts to be valid, the delivery, and so on and so forth. We don't have to get into the details of that, but it's good to go and do it. I have had people who have called me. It's very interesting. So I quote them, obviously, for doing the service. You have to be paid, right? If not, I have staff as well, rental and all that. So everybody needs to be paid. So I charge them a very small amount. Let's just say, I won't say for what, but I'll just say, let's say I just charge 1,000 flat, okay? So with GST is 1070. And this person has 4 properties. 4 properties. And I said, he wants to know because he has properties and he has certain, complex scenario, factual scenario. So I told him, you have to come down, you have to execute this document. I will also explain to you about other things. So generally his assets, if I believe, was probably, as why he's telling me, about $12 million. But when I quoted him $1,000, he got a shock. He said, this is very expensive, sorry. This is high side. Can you lower down? I said, how much you look at? Maybe $100, $200. I said, sorry, I can't do that. So at the end of the day, I would also, my advice to people would be, you must take a practical decision. Obviously, just to probably save a few $100 or $1,000. I'm not saying everything is 1,000. Some things can be 500, some things can be 5,000. It really depends what you do it for. I'm not here to list out the services that lawyers provide. But I'm just giving an example just to save a bit, don't cause confusion at the end of the day. Because it can cause a lot of issues. It really depends also. A lot of people don't know whether they are owning the flat in joint tenancy or tenancy in common. When you ask them, they don't know. Say, how do I know? I said, you're the owner, you should know. So go and find out. Check the title deed and all that. Check it out. Go to the HDB page. I think my HDB page will be able to tell you whether it's a joint tenancy or tenancy in common. So just go and find out. These things are important.
Thank you very much, Rizuan. On that note,
Can I just thought that something I think you mentioned, I think is very important for us to bring back also. Because you mentioned that, do it when you're alive. And I think when we're doing both sides now, all along what we're saying is that, let's not wait until the last moment to have such conversations. And at the same time, in order to have these conversations, we're really looking at relations also, right? Whether family members are okay to talk about it, they feel comfortable, are they open enough? Or who should I be talking to? Who are the people I trust? And I think that's that kind of community or that kind of a setup we must look forward to. And as well as, like what he said, do the conversation early so that, then you are prepared. If not, then we'll have a lot of that kind of contestation which will make the grieving process even more complicated with all this piling on top. And I think here, we're not saying that, we can remove grief, but we just want to make things, becomes easier for you to manage, but rather than we want to solve all this problem. Yeah. Mm-hmm.
And I think it is also a reflection of why we've been doing the things that we've been doing this past couple of nights, to just highlight that these conversations do have a place and are important, not just for your psychological and mental well-being, but also to ease the actual practicalities of dealing with an issue, especially when grief can really engulf you.
So, I wrote, because I am the kind of person that I need to write it down. So what I have wrote here, what I have learned for the past few days or so, and also today a lot actually. So death is a natural order of things. Planning your end of life matters should not be a taboo. It is not determining whether you want A or B. It is about learning what matters to you most when life put you in a certain kind of situation. So I think what is happening, we have been doing this for so many years. So each year, what I discover is that this conversation is not just a one-day conversation, not just an hour kind of conversation. It's supposed to be a continuous conversation until you say goodbye, or sometimes, goodbye are not even said. So before there's regrets, there's guilt, I guess we should start having this now. What matters to you most? Kata-kata kita.
Thank you very much, Molly.
Thank you.
Thank you very much, Rizuan.
Thank you, Rizuan.
Let's welcome back Gloria and Hatta
Thank you, Rizuan.
to bring us home.